So this is at the hearings. Do you have any practical tips for us who are preparing for the pretrial conference, the hearing itself?
Right. So I have three tips for this.
Okay.
The first tip applies to any hearing that you're going to be involved in your litigation. And that is to make sure that you are very prepared. You know your file backwards. You know every single document of your own documents, and you know every single document of the other side's documents. You know the issues, you know the law, and you're very comfortable navigating your documents and navigating the other side's documents. That'll help you in a lot of ways. I mean, obviously, just understanding your case is going to help you. But if a judge at a pretrial conference looks at everything, reads the discovery transcripts, reads the pretrial conference memos and all that stuff, and takes a completely different perspective of the case than you have, if you aren't prepared, you're not going to be able to respond. Right. So if he says, well, I looked at, this document found in tab 36 of whatever, and it says this thing there that makes me think the whole thing's whatever.
Yeah.
You should know what he's talking about, and you should know where to find the document. You should know how to respond to that document or something, but you have to have like the tiniest little sentence somewhere. You should know it. Right.
Right.
And, that might sound excessive, but it's not, because this is a lawsuit you're in, serious business. You got to know everything. It's not just a joke, right? That's how prepared you need to be. So that's number one. Number two is be prepared to settle. Okay. And when I say that, I don't mean that you have to give up your case when you go to a pretrial conference. But you have to take the settlement aspect of it seriously. And you have to say, I'm willing to work with the other side to resolve this issue. This is a very hard thing for a lot of people to do, because they get very emotionally, ingrained in their case. And they also get very financially stuck in their case because they've spent a lot of money up to this point as well. Right.
Yeah, absolutely.
But there's never a guarantee at trial. And a judge is going to look at you and say, yeah, you might be right about everything you're saying in this case, but there's never a guarantee in trial. Your star witness might not show up or have a headache or forget everything or whatever. There's never a guarantee. And there's a certain amount of monetary value that you need to attach to that risk, that non-guarantee. And you have to be able to at least say, I'm willing to give up something to account for that risk to have a settlement today. You have to be able to do that, even if it's a little bit. But if you don't, the judge is going to look at you like you're unreasonable. So you have to be ready to settle. You don't have to say, I'll give up everything I want, but you also can't sit there with your arms folded and say, no, I'm not participating in any settlement discussion. I refuse. It's either everything or nothing. You can't do that. You have to be prepared to settle, even if it's for a tiny little bit. You have to be able to show that judge that you're taking the settlement part seriously and you've thought about it and considered it. That's very important. And if you don't really do that, your settlement conference is going to be a waste of time, I think. Right. So again, I'm not saying you have to give up everything that you came here for, but you have to show the judge that you've thought about settling, and you can justify your thoughts somehow. So that's number two. And number three is, if you're not going to settle, you got to be prepared to schedule everything else. So you have to have your calendar with you, and you have to be ready to set the dates for your trial, the dates for your witnesses, all that kind of stuff as well. So it's 1, be prepared, 2, consider settlement, and 3, be prepared to schedule.
Those are excellent points. Dan, something else popped into my head. At the hearing, because you said that this pretrial conference is not about arguments. So I am so stuck in that whole mode about, being a litigator and arguing. So at a conference, are the parties allowed to give opening remarks? Like, I'm just curious about, I know that probably every pretrial conference is slightly different depending on the style of the judge. But are there conferences where the judge will go, okay, you tell me a little bit about not your case, but like whether you're prepared to settle and how are you prepared to settle. So it's a little bit like opening remarks. Is this reasonable to expect in the structure of a hearing?
It's very reasonable to expect. I don't want to have any misunderstanding. A pretrial conference is a lot about arguments. The pretrial conference brief shouldn't contain arguments, right? So when you're actually at the pretrial conference, you're going to be part of negotiating is always going to be arguing, right? So there's going to be arguments.
Okay.
But you're right to say that every judge is going to do it differently. But yeah, you should expect to give some sort of position of what you think the issues are, what you want, and all that kind of stuff. Whether it's done through a formal opening statements, which I have seen before, or whether the judge wants to facilitate the pretrial conference in a more creative manner. You should be ready to deal with both of those scenarios, I would say.
Wow. So that is a little bit, in a way it's harder. Like, I'm thinking at a trial, that there's a structure that's followed, right? Basically the plaintiff starts and they may have opening arguments, whatever they call witnesses. So you know what to expect, right, in a trial. But in this pretrial conference, it seems like it's a little bit vague as to what to expect in terms of a structure.
Absolutely. And I would think of it in that respect, similar to mediation. It's just going to be how a judge wants to do it. And another thing that you said, which I'll just pick up on, was in a trial, you know what to expect. Well, in the trial, you're going to know what to expect because you've figured it all out at the pretrial conference. Right? You figured it out. This is how long I'm going to have for opening statements. This is how long I'm going to have my first witness. This is how long it's going to be for cross-exam. This is the day we're going to do it. That's all going to be sorted out at your pretrial conference. Right.
So that's really a great thing that the pretrial really does sort of streamline the process, actually.
Exactly. And if you're on good terms with opposing counsel, or even if you aren't, you should still try to settle a lot of this stuff beforehand.
Yeah.
Right. So that you can go in there and say, look, listen, Your Honor, we've already, a lot of the little nitty gritty, we've already figured it out, like how many witnesses and when and how long we need and things like that.
Yeah.
That'll help you. Right.
Sounds very reasonable.
Another tip, which is a little bit more practical rather than substantial, is, especially in Toronto, if you've got a 1 hour pretrial conference booked, book off the whole day. Tell your client to book off the whole day and be there ready to stay from morning till night. Things get delayed. And sometimes if a judge thinks that your conference is going to produce something positive, but it's just going to need some more time, you might get that more time. So you never know how they're going to unfold. So make sure you're just available.
That is a great tip.